Good evening and welcome. My name is Carmen Leslie Ward, and it is an honor to serve as president of the Trinity Club of Hartford. This evening, our speaker series is about the Roberts Court. Matt Smith, class of '82, will be our moderator. Matt has a long legacy with the college. His father is a graduate of Trinity, as well as his mother was a graduate in the master's program. A number of Matt's siblings and cousins also attended Trinity College. He met his wife, Ellen, at Trinity. Their daughter graduated in the class of 2019, and Matt Smith will now begin our series.
Great. Thanks, Carmen. Good evening, everyone, and thank you for joining us. To begin, our talk will be followed by a question and answer session, so please type your questions into the Q&A box at the bottom of the screen. The Trinity Club of Hartford Speaker Series is dedicated to informing and educating members of the Trinity College community about issues central to Trinity's vitality. The objective of the series is to provide an honest view of an issue from an informed perspective. Tonight, we will discuss the Roberts Court, their recent decisions, and implications for state law in general and Connecticut law in particular. Leading us through this review are three distinguished Trinity alumni, all with deep legal experience. First, retired Connecticut Supreme Court Justice Richard Palmer. After helping build Trinity's squash dynasty as team captain and a first-team All-American, Richard Palmer graduated from Trinity Phi Beta Kappa with a Bachelor of Arts degree in 1972. He followed up this success by graduating with his Juris Doctorate with high honors from the University of Connecticut Law School in 1977. Upon graduation, Justice Palmer served as law clerk for Judge John O. Newman of the U.S. Court of Appeals for the Second District. He followed that by practicing with Shipman and Goodwin before serving as Assistant U.S. Attorney and U.S. Attorney for Connecticut. His extensive private and public legal experience culminated with his installation as Associate Justice of the Connecticut Supreme Court on March 17, 1993. He served in that capacity until 2020. Joining Justice Palmer is Connecticut Superior Court Judge Claudia Baio, class of 1986. A Hartford native, Judge Baio attended Trinity and was recognized as the President's Fellow in Educational Studies, Faculty Dean's List, and was the recipient of the Richard K. Morris Book Award for Excellence in Education. Following graduation from Trinity, she earned her Juris Doctor from the University of Connecticut Law School in 1989, the same year she was admitted to the Connecticut Bar. Following a clerkship with the Honorable Fleming L. Norcott, Jr. at the Connecticut Appellate Court, Claudia entered private practice at Gordon, Muir & Foley, rising to partner, then started her own firm. She was appointed to the Connecticut Superior Court in 2018, where she currently serves. Ernie J. Mattei, class of 1970, practiced law for nearly 50 years with passion and professionalism. In December 2020, he retired as partner at Day Pitney, LLP. Ernie practiced as a trial lawyer in the area of complex commercial disputes, with emphasis on insurance coverage and defense. His substantial trial experience includes cases in state and federal courts across 11 states. In retirement, Ernie remains active in the Hartford County and Connecticut Bar Associations. He is also a member of the CBA's Litigation Section Executive Committee and is co-chair of the Experienced Lawyers Committee. Their collective experiences make Justice Palmer, Judge Baio, and Mr. Mattei uniquely qualified to examine the Roberts Court, its decisions, and their impact on state law, in particular, Connecticut, and by extension, Trinity College. So with that introduction, I will turn it over to the panel to begin the discussion. But before I do, please, I just want to remind the audience to type their questions for the panel into the Q&A box at the bottom of their screens. And with that, I will turn it over to the panel.
Thank you, Matt, for that lovely introduction. And we are honored to have Justice Palmer with us as our primary speaker this evening. And as you'll learn throughout the presentation, he is perfectly suited for this because he's actually authored some of the decisions that are significant and that you'll be hearing about tonight. I know the focus of tonight's discussion is on the Roberts Court, but our thought was that it might be helpful to the audience to put this in context and for you, Justice Palmer, to share a little historical background or overview of the role of the U.S. Supreme Court.
I'm happy to do that, Judge Baio. Thank you very much. And thank you, Matt, for your kind introduction. And to Judge Baio and Ernie as well for participating this evening. I'm honored to be joined by such distinguished Trinity alumni. I look forward to discussing the Roberts Court from my perspective as a former member of the Connecticut Supreme Court and trying to explain why the direction that the Roberts Court has taken has dramatically increased the significance of state constitutions and state Supreme Courts really around the country. Now, in response to Judge Baio's question and by way of background, the federal Constitution, as you no doubt know, is the supreme law of the land, and as such, it takes precedence over all other federal laws and as well over state laws, including state constitutions. That state constitutions and state laws that conflict with the federal Constitution. And of course, the U.S. Supreme Court is the ultimate authority as far as interpreting the federal Constitution is concerned. Now, frequently, though, lower courts, both federal and state, are called upon to interpret the federal Constitution. And when the U.S. Supreme Court has spoken on an issue, those lower courts are required to follow what the U.S. Supreme Court has held. Other times, when the U.S. Supreme Court has not ruled directly on a particular constitutional issue, the lower federal or state court must do its best to determine, really to predict what the U.S. Supreme Court would do if it were confronted with that same issue. Now, for about the last 50 years or so, the composition of the U.S. Supreme Court has taken on increasing significance because of what's become something of a split in the way the justices of that court go about deciding constitutional issues. Now, what I'm about to say is a bit of an oversimplification, but broadly speaking, there are two primary schools of thought, two primary methodologies about the way justices and judges should interpret the federal Constitution. One such methodology is known as originalism, and that's an approach to construing the federal Constitution that's based on the premise that the Constitution should be interpreted in accordance with the original meaning of the word that the words of the Constitution had when it was adopted by the framers. The second primary method of constitutional interpretation also looks to the text or language of the Constitution, of course, but it asks, as one former Justice William Brennan put it, and I quote, "What do the words of the text mean in our time or today?" Because as Justice Brennan further stated, the genius of the Constitution rests not in any static meaning it might have had in a world that is dead and gone. Now, this method of interpreting the federal Constitution has been characterized as the living Constitution approach, because it treats the Constitution as a document whose meaning evolves over time. Now, until the 1980s or so, the dominant approach used by the justices of the United States Supreme Court in interpreting the federal Constitution was this so-called living Constitution method. That approach was notable in a number of landmark cases decided by the court when it was led by Chief Justice Earl Warren in the 1950s and 1960s. In those Warren court decisions, prominent among them are Brown versus Board of Education, the watershed school desegregation case that overruled Plessy versus Ferguson, and Miranda versus Arizona, the famous advisement of rights case, took a broad or expansive view of the rights afforded, or many of the rights afforded under the federal Constitution. The originalist approach to construing the federal Constitution more or less developed in reaction to these decisions of the Warren Court, and as well to a case that came shortly after Chief Justice Warren retired, Roe v. Wade, which was decided in 1973. Interestingly, one of the very first and most prominent adherents to the originalist view, and I remember this well, I'm dating myself more than a little, but was Robert Bork, the Yale Law School professor and federal appeals court judge, who was nominated to the U.S. Supreme Court in 1987 by President Reagan, but whose confirmation was defeated in the Senate because of a concern that he could be the swing vote, or he would be the swing vote in overturning Roe v. Wade. Now, Judge Bork died several years ago, but as I'll explain shortly, his originalist view opposing Roe v. Wade has now become the law of the land. And parenthetically, the bruising confirmation battle that cost Judge Bork a seat on the U.S. Supreme Court set the stage for much of the acrimony that we see today in the nomination and confirmation process relating to the Supreme Court. Well, for quite a few years, the 9 members of the Supreme Court were rather evenly divided between these two interpretive approaches, the originalist approach and the living Constitution approach, with Justice Sandra Day O'Connor and then later Justice Anthony Kennedy serving as deciding votes, sometimes siding with the originalists and other times siding with the living constitutionalists. However, when Justice Kennedy retired from the court and President Trump replaced him with Justice Brett Kavanaugh, and then when President Trump appointed Justice Amy Coney Barrett to the court following the death of Justice Ruth Bader Ginsburg, the originalists became a solid voting majority of the court.
Your Honor, as you know, and Judge Baio, we were always taught that the Supreme Court was absolutely neutral, not a political body, and that they might have different approaches to interpreting the Constitution, but certainly wasn't based on any political agenda. And now we listen to commentators and analysts, and when they refer to a judge, they tell you who appointed it. It was Reagan, it was Trump, it was Obama. From your perspective, do you see whether the court has become politicized, or is this just justices who are looking at these cases with a different approach or a different methodology for interpreting the Constitution?
That's a very good question, Ernie, and I think it's the latter, actually. It's clear that the appointing authorities and then the senators who are involved in the confirmation process, are political actors. But the justices, most of them over the years, have been judges before. And what distinguishes them one from the other is not really whether they're a Democrat or a Republican or an independent, but rather what approach do they take regarding the proper interpretation of the federal Constitution. And so I think it is true, I think, that the Republican presidents over the years have tended to appoint judges who at some point down the line may adopt an originalist approach to interpreting the Constitution. And Democrats maybe, more often than not, appoint justices who take the living constitutionalist view. But I think it's actually unfair to the justices of the court and to the court itself to describe that body, or to characterize that body, or to consider that body, as a political body, like the legislature or the executive branches, like the elective branches, which are really, they are political bodies, and they're intended to be. Is that helpful?
Yes, I think so. Yes. By the way, Justice Palmer, people seem to forget that there are justices who are appointed by Republican presidents who actually turn out to be much more liberal than they were expected to, and actually Chief Justice Warren is a perfect example. Absolutely right,
and so is Justice Brennan, who was also appointed by President Eisenhower, who was a Republican, that, and in fact, you used the word turned out to be, or the expression turned out to be more liberal, and thereby sort of giving a voice to this distinction between a liberal judge and a conservative judge. And I think in general terms, those people are identified. The liberals, so-called liberals on the court, would really probably identify with the living Constitution approach, and the conservatives would be more apt to identify with an originalist approach. And that's just there's a very rough equivalence there, I think. As I mentioned, the originalist justices now make up a majority of the court, and the significant and dominant role that the originalist interpretive approach now plays on the Roberts Court is probably best exemplified by the court's recent decision in Dobbs versus Jackson Women's Health Organization, the abortion case that was authored by Justice Samuel Alito that overruled Roe v. Wade. According to the court in Dobbs, the majority of the court in Dobbs, and contrary to Roe v. Wade, there is no constitutional right to an abortion, no federal constitutional right to an abortion, because no express reference to the right can be found in the constitutional text. And because it's not a right that's so deeply rooted in our history and tradition that it may be deemed fundamental. Those generally are the considerations that the originalist justices take into account in determining whether the Constitution recognizes a particular right. Another extremely important case recently decided along originalist lines by the Roberts Court is the New York State Rifle and Pistol Association versus Bruin, a case which addressed the constitutionality of New York's gun law that required a license to carry a concealed pistol outside the home, a license that would be granted only if the applicant could demonstrate a special need over and above a generalized interest in self-defense. Concluding that the Second Amendment's right to bear arms, as understood at the time the Second Amendment was ratified way back in 1791, permitted the carrying of a concealed pistol without the kind of limitation imposed by the New York statute. The court, in an opinion by Justice Clarence Thomas, used the originalist approach in relying on the language and traditions underlying the Second Amendment to declare the statute unconstitutional. So an important question becomes, what do these cases and others decided by the current Roberts Court mean for future cases involving the federal Constitution? And this question, I think, is particularly important because the originalist majority of the Roberts Court is likely to remain intact for quite a few years to come. Well, in the view of many legal scholars, the interpretive analysis employed by the court in Dobbs and Bruin may very well place other highly significant cases in serious jeopardy of being overruled. Now, these cases include a number of the court's most well-known and far-reaching decisions, some of which predate Roe v. Wade, and they include Loving versus Virginia, which recognized a right to interracial marriage, and Griswold versus Connecticut, which struck down statutes barring the use of certain kinds of contraception, and other cases that are more recent but no less momentous. For example, Lawrence against Texas involving sexual intimacy, and Obergefell versus Hodges, which is the case that recognized the right to marriage equality for couples of the same sex. Now, like Roe v. Wade, all of these cases, to one degree or another, were predicated on rights of privacy and bodily integrity, rights that may well be incompatible with the reasoning used by the Dobbs majority in reversing Roe v. Wade. And that's because, like abortion, the rights recognized in those cases, most notably the right to privacy and the right to same-sex marriage, cannot be found in the text of the Constitution, nor are they deeply rooted in our history and traditions, the considerations that sounded the death knell of Roe v. Wade and the right to an abortion in Dobbs. Now, of course, every case is different, and the opinion in Dobbs stated expressly that that case should not be read as imperiling any case other than Roe v. Wade. But as at least one member of the Dobbs majority, Justice Thomas, is on record, he's on record expressing the view that Dobbs effectively rejected a constitutional right to privacy and rejected a right to same-sex marriage. Whether those and other cases ultimately are overruled, though, it seems reasonably clear that the Roberts Court employing the originalist method of interpretation is not likely to be recognizing new or novel rights under the federal Constitution.
So Justice Palmer, perhaps this is a good time to start talking a little bit about the importance and difference and involvement of our state Supreme Courts. We have all read and heard comments consistently and consistent with some of the remarks you've made tonight as well about the conservative direction of the Roberts Court and how it's changing constitutional law. And sometimes in that discussion, I think the impact and the importance of our state Supreme Courts may be overlooked. People don't necessarily know the difference or how that makes, how that could have far-reaching changes. So how much impact does this have on states like, for instance, our own state of Connecticut, where the views of and the rights under the state constitution may be different from those of our U.S. Supreme Court and perhaps more broadly construed, in particular, since state courts can do that, afford broader rights?
Yes, the approach that the Roberts Court is taking has had and will continue to have a very significant effect on state constitutional jurisprudence. Let me, before I get into sort of the heart of that question, what I'd like to do is just give the listeners a little background on the state courts and constitutions, which frankly have generally not been very well known to the public because of the historical preeminence of the U.S. Supreme Court and the federal Constitution. But importantly, each state has its own constitution. And in fact, between the years 1776 and 1787, that is in the years before the ratification of the federal Constitution, most of the original states, original 13 states, had ratified their own constitutions. Now, these and later state constitutions of states that became states subsequently, grant substantial rights to the people in those states. And the language used in those constitutions and in the federal Constitution is often very similar, if not identical. Following the ratification of the federal Constitution, though, back in 1791, and until quite recently, those state constitutions were essentially forgotten and neglected as a source of rights independent of the federal Constitution. This began to change shortly before I was appointed to the state Supreme Court in 1993. At that time, a small handful of state Supreme Court justices, one of whom was Chief Justice Ellen Peters of the Connecticut Supreme Court, who was the first female justice of the state Supreme Court and the first female Chief Justice, and before that, the first tenured female law professor at Yale Law School, really quite a scholar, began to write about the rights and privileges enunciated in state constitutions. And gradually, lawyers, law professors, and judges started to consider state constitutions as providing a source of rights separate and distinct from the federal Constitution. Now, the United States Supreme Court has held that under the supremacy clause of the federal Constitution, which states that federal law invariably takes precedence over conflicting state law, state constitutions cannot limit the rights afforded our citizenry under the federal Constitution. That's because if a state constitutional provision purported to limit rights recognized under the federal Constitution, that state constitutional provision would be in conflict with the federal Constitution. And as I said, under the supremacy clause, that conflict would have to be resolved in favor of the federal Constitution. However, the U.S. Supreme Court has also held, as Judge Baio suggested, that state constitutions may be the source of individual liberties more expansive than those conferred by the federal Constitution. That is, state Supreme Courts are free to recognize rights in their state constitutions that have not been recognized under the federal Constitution. Put differently, state Supreme Court justices may interpret the provisions of their constitutions more broadly than the U.S. Supreme Court has interpreted the federal Constitution. And that's true even if the provisions of the state constitution are identical to the provisions of the federal Constitution. And there are many such important provisions that are identical, such as the right to due process and the right to equal protection. They appear verbatim in both the federal and state constitutions. I'd like to make one additional point with respect to state constitutions and state Supreme Courts. While the U.S. Supreme Court has the ultimate authority to decide all questions arising under the federal Constitution, it does not have that same kind of authority over state constitutions. Rather, it's the state Supreme Court that has the ultimate authority over state constitutions. And that state Supreme Court cannot be reversed, even by the U.S. Supreme Court, when it comes to interpreting the Constitution of the state. In other words, while the U.S. Supreme Court has the final word on interpreting the federal Constitution, state Supreme Courts have the final word on interpreting their own state constitutions. So if a state Supreme Court recognizes a right under the under its state constitution, there is nothing the U.S. Supreme Court can do about it. Now, as I've indicated, it's widely presumed that, generally speaking, the Roberts Court majority, with its originalist approach to interpreting the Constitution, will be taking a more limited view of the rights afforded under the federal Constitution than previous U.S. Supreme Courts. Dobbs, of course, the abortion case, is the best such example, and also, no doubt, the most controversial, in part because the abortion issue has generated so much controversy over the years. Now, in response to Dobbs, litigants in many different states are asking their state Supreme Courts to recognize the right to an abortion under their state constitutions. Among other states, this litigation has been initiated in Florida, Indiana, Kentucky, Missouri, Utah, South Carolina, Wyoming, and Oklahoma. All states where there is currently a legislative ban on abortion, or where abortion is otherwise disfavored by the electorate. And while Dobbs and the abortion issue are hugely significant, the Roberts Court appears committed to the originalist approach in the interpretation of the Constitution generally, in all different kinds of cases. And so the legal consensus is that those interested in broadening or expanding constitutional protections generally had better do so in the context of state constitutions, not the federal Constitution.
Your Honor, there's I think an example of what you've just said, and which I think would be surprising to the listeners, is the recent decision. In fact, it was filed in 2022, but there was a rehearing in 2023, and then it was finally printed in 23, was a decision out of the South Carolina Supreme Court, where the South Carolina legislature had banned all abortions after 6 weeks. Of course, the argument that most women would not know that they were even pregnant within the 6 weeks fell on deaf ears to the legislature. But because the South Carolina Constitution, the state constitution, had a specific right to privacy, the South Carolina Supreme Court concluded that that legislation was unconstitutional under the state statute and therefore was void. And I think that's an example of what you were talking about. Is that correct?
It is. It's an excellent example, Ernie. There are others, but I think that's a particularly profound example because, as you've indicated, most of us, especially those of us who don't know anything about the South Carolina Supreme Court, might think that court would be disinclined to override the state legislature on an issue like that. But they did, and other state Supreme Courts and other judges in other states that might be described as conservative politically, no doubt will do the same thing. How many and where is really anybody's guess. But that litigation is pending.
The name of the case out, just because I know there might be some students who might be interested. It's a long read.
Sure.
It's Planned Parenthood South Atlantic versus G. Murrow Smith, and then a whole bunch of other names. Do you have the site, Ernie? I don't have the site.
Yeah,
with me.
882 Southeast 2nd, 770, South Carolina, 2023.
And folks, this might be a good time to just interject with a question from our audience. George Wendell, class of 65, asks, in Dobbs versus Jackson, the U.S. Supreme Court overruled the line of right of privacy cases stemming from Roe v. Wade, essentially allowing individual states to determine whether a woman has a right to abort an unwanted pregnancy. To me, this sounds like giving the choice of a woman's future to state legislatures. But is this not an affront to the 13th Amendment, which abolished slavery and involuntary servitude? Any thoughts why such reasoning is not effective?
It's a lot packed in that question.
Yes,
Palmer,
That's
let's go first.
Yeah, I don't think that, I'm not certain about this, but I don't think that the Dobbs court actually addressed that claim. Do you have a different understanding, Judge Baio or Ernie?
No, I don't, I'm pretty certain it didn't.
I don't think so either.
13th Amendment basically freed the slaves. I don't know what would be the relationship. It's probably going to require someone a lot smarter than I am, but it might be a unique and interesting approach to the right of privacy. But I would think that between the 14th Amendment and the state constitution's, rights to privacy, like South Carolina, that's where the focus would be.
Yeah, I don't see the nexus between those, and I am fairly confident. I'd certainly read it again to be sure, but I just don't think there's anything that brings that as an issue in the Dobbs case. But I think that also that case, as Justice Palmer pointed out, shows the importance of state Supreme Courts and the rights that can be afforded under state Supreme Courts, that even if the federal courts don't allow certain things to be found under, or find that they don't apply under the U.S. Constitution, that's the difference we're trying to show, is that you can, under the state Supreme Court, our Supreme Court justices can find broader rights, but they can't find more restrictive rights. In other words, the floor for everybody is what the United States Supreme Court finds our U.S. Constitution holds. That's the floor. And then the state Supreme Courts can give greater rights. We see them in other contexts that I know that the justice is going to talk about in a little bit. I don't know if that answers the question or not, but.
No,
I just
great.
have one additional point to make, and that is that that argument, the 13th Amendment argument, I don't think it was made. If it was, I apologize. But if it wasn't made, it was no doubt because the proponents of the constitutionality of a right to abortion were of the view that the stronger argument and the best argument that they had was to rely on Roe v. Wade and the reasoning behind Roe v. Wade and the Griswold case and cases like that preceded Roe v. Wade. And as a matter of appellate strategy, it's frequently better to sort of go with your strongest argument than it is to take the court's time considering weaker arguments, because that can actually weaken your better argument. So I don't know if that's helpful or not, but that's that may have played into the equation in terms of whether that argument was raised at all.
Mm-hmm. Okay. One additional question that's kind of that's building off comments you made earlier, Justice Palmer. One attendee has asked, what is your perspective on the argument that the U.S. Supreme Court can rule that state legislatures have authority over their respective state Supreme Courts to determine voting procedures within their states?
Yeah, you might not be surprised to learn that I haven't studied that issue carefully, but I am aware of it, and you may not be surprised to learn that I don't find it to be a persuasive argument. I don't think that the federal Constitution, either expressly or implicitly, bars state Supreme Courts from determining that a legislative decision concerning election law, redistricting, whatever it is unconstitutional under the state Constitution. Just as the federal Constitution is the supreme law of the land for federal purposes, so are state constitutions and state Supreme Courts in the various states. So I'm not I've read a little bit about the argument of that case before the U.S. Supreme Court, and it's really hard to predict based on commentators' views of what occurred there, but it didn't sound like even the originalist members of the court, or at least some of them, were persuaded by that argument.
But it's a timely question because it's a very concerning question. And in fact, the thought of a legislature having control over the highest court in a state is frightening to me. We've seen what happened in Kentucky just recently, where their legislation that was passed was overruled by the Democratic governor, and they immediately overrid his veto by a 75 to 25% majority. So a lot of these legislatures, because of what they've done in terms of gerrymandering their districts, are in control of people who want to limit rights. And so this is, to me, is a very significant question.
Yeah.
Matt, if I can,
please.
one of the things that our listeners may not know is that at one time there were cases in the Connecticut Supreme Court were decided by 5 justices, and for a very significant period, 2 of those 5 justices were Trinity graduates. In a state where you have Yale Law School, you have Quinnipiac Law School, and others, it was remarkable that Trinity College would have 2 jurists of such qualifications that they would be sitting on the state Supreme Court. And to me, it's a nice segue to actually point out, because I know Justice Palmer would never do this, but Justice Palmer, over his career, has written well over 600 decisions, I believe. I think I'm in the ballpark, but has written some of the most seminal and important decisions in Connecticut, and wrote 2 decisions, which I'd like to have him discuss because they fall very neatly into this whole issue of whether a state can grant greater rights than those that are provided under the U.S. Constitution. Do you mind doing that, Judge?
No, I'm not so modest that I mind terribly, but thank you, Ernie. I will. I actually want to say one thing first, if it's okay, and that is that the widespread perception of the growing importance of state constitutions, and as a result, the growing importance of state Supreme Courts, has manifested itself in a number of ways, both big and small. Now, one small example of this is that courses in state constitutional law are now being offered in many of our most prestigious law schools. I know Hartford and Stanford now have courses that teach state constitutional law. Previously, there were no courses like that taught anywhere. Far more significant, though, is that many state Supreme Courts are comprised of elected justices whose campaigns have now become the subject of intense political interest and fundraising. I'm not suggesting this is necessarily good, but it's happening. I'm not a big fan myself of elected judges. I don't think there's even an iota of a chance that I would be a judge if I had to be elected. So I'm a little biased, but perhaps the best current example of this is Wisconsin, where there's an election next week for a swing seat on the Wisconsin Supreme Court. And I read that as of a couple of days ago, over $31 million had been spent on behalf of the 2 judicial candidates on advertising alone. Now that really would have been unheard of in the past, but it gives you some idea of the importance that's placed on the election of this one particular Supreme Court justice.
Wow.
Justice Palmer, before you start talking about the other cases, and I believe Ernie was referring to Kerrigan and Santiago because we talked about this earlier, But I just want to say, first of all, I think we're fortunate to be in a jurisdiction where we don't have elected judges for exactly the reasons you're talking about. Having been both an elected official and a judge, it has its place, but that it just that's a different issue for a different day. So I won't go too far afield with that, but I think there's very good reasons why it's better to keep that separate. And the only other thing I would throw out before we throw the ball back to you, Justice Palmer, is if there's time, and I know we may run short, but after you've finished discussing the two very important cases of Kerrigan and Santiago, if there's time, I'd love to hear what you have to say about the State versus Correa, and just so that the audience knows, that's an area that often, even before these new issues, that was the area where you would see the state Supreme Courts giving broader protections because it was in the area of search and seizure. And there's a whole lot packed in there, but in particular, the issues relating to the underlying argument or underlying issue that was there regarding the dog sniff in the hotel.
Okay.
If there's time, I'd love for you to get to that.
Sure, I'm happy to. Well, let me tell you a little bit about the Connecticut Supreme Court, which for at least the last 25 years or so has been receptive to interpreting the state constitution as a source of greater rights than the federal constitution. Many of those cases have been in the criminal area, as Correa was, in particular search and seizure cases. Again, Correa was a search and seizure case. But let me give you another example first, a case that dates back to a time a few years before I was appointed to the court. Under the federal constitution, if the police obtain a search warrant from a judge and seize contraband, drugs or guns or whatever, upon conducting the court-authorized search, and it turns out that the warrant application doesn't contain the required probable cause, which is the quantum of evidence that's constitutionally required, that evidence is not suppressed under the federal constitution. That is, it's admissible at trial, even though the warrant is defective, because the police were acting in good faith by getting the warrant. It's called the good faith exception to the suppression requirement, suppression rule. But here in Connecticut, our Supreme Court has held that there is no such good faith exception under the state constitution. So in that same circumstance, where the warrant is determined to be defective, the evidence will be excluded. It will be suppressed, even though the police acted in good faith in obtaining the warrant. Now, I'm not expressing an opinion as to whether or not that's good public policy or it was rightly decided under the state constitution, but that's an example in the area of search and seizure that goes back quite a number of years, where the right of the defendant in that case is deemed to be greater than the right than his rights would be under the state constitution, than greater than they would be under the federal constitution. Now, a primary reason why the Connecticut Supreme Court has been willing to recognize these additional rights above and beyond those recognized under the federal constitution is because the state Supreme Court here has generally adhered to a different view of constitutional interpretation than the originalist approach of the Roberts Court. Instead, the state Supreme Court has applied the so-called, by and large, applied the so-called living constitution methodology. And to quote briefly from a recent case from the state Supreme Court on that subject, that methodology is premised on the view that, quote, we must interpret the Constitution in accordance with the demands of modern society, or it will be in constant danger of becoming atrophied and in fact may even lose its original meaning. The Connecticut Constitution is an instrument of progress, and it is intended to stand for a great length of time and should not be interpreted too narrowly or too literally so that it fails to have contemporary effectiveness for all of our citizens, close quote. And so there are quite a few cases in which our state Supreme Court over the years has interpreted the state constitution as affording rights above and beyond the federal constitution. And as Ernie indicated, Judge Baio,
We look alike. It's okay to confuse us.
That's the greatest compliment Ernie has ever had.
That's right. I'm writing it down right now.
I'll briefly, I'll be brief about these, but one of them, which was mentioned, is Kerrigan versus Commissioner of Public Health, which was decided in 2008, in which we concluded that under the equal protection provisions of the state constitution, same-sex couples have the same right to marry as heterosexual couples. At that time, there was a civil union law in Connecticut, so same-sex couples were entitled to be bound by a civil union, but not marriage. They were foreclosed from marrying, and at that time as well, the U.S. Supreme Court had rejected the same claim, a right to same-sex marriage under the federal constitution. And so we were the third state after Massachusetts and California to recognize that right. It wasn't until 2015 that the U.S. Supreme Court reversed itself and decided that same-sex marriage was protected under the federal constitution as well. That case, the Obergefell case, is a classic example of Justice Kennedy serving as the swing vote in a 5-4 case. Another case that was mentioned is State versus Santiago, which decided in 2015. And we held in that case that the state's death penalty statute violated the state constitution. I don't have time to go into detail about that case, but what happened is that the state legislature had repealed the death penalty for all future cases, but it kept it intact or in effect for the people who were then on death row. And we concluded under the state constitution that violated principles in the state constitution. I think it's pretty clear that that would not violate the federal constitution. And in fact, no federal constitutional claim was actually even brought to our court. So it was decided on state constitutional grounds. In most cases, and where the state Supreme Court has decided cases under the state constitution affording greater rights to citizens, there's not much of a public reaction, really, one way or the other. But quite understandably, the gay marriage case and the death penalty case were both controversial and generated strong feelings on both sides. But fortunately, though, and this sort of gets back to what Judge Baio said, in Connecticut, where judges are nominated by the governor and confirmed by the legislature for 8 years and not elected, we have a strong history of judicial independence. That is, the two elected branches of our government don't remove or demote judges merely because they may disagree with their decisions. I want to, if we have time, I'll discuss the Correa case briefly, but talking about judicial independence, I just want to mention that that's not always the case in other states, especially in states that elect their judges. And a good example of this is something that happened in Iowa in 2009, the year after we decided the gay marriage case here in Connecticut. The Iowa Supreme Court, really following our decision, its legal reasoning, concluded unanimously that there was a right to same-sex marriage under the Iowa Constitution. But as I say, in Iowa, state Supreme Court justices are elected, and all three of the justices who were up for re-election the year after the Iowa case was decided were voted out of office. Now, from my perspective, that's very unfortunate. And I'm very thankful that, that's not the case in this state. With respect to the Correa case, that case involved a claim that a dog sniff of a motel room that was really open to that the public could enter. It was not a locked corridor. The claim was that constituted a search and seizure under the state constitution. Now, I don't think the U.S. Supreme Court has opined on this issue, but it's quite clear based on other federal cases, that there is no federal constitutional right there's no right of privacy that would bar the police from using a canine without a warrant, that is, without a warrant, to conduct a sniff of the room to determine whether there may be contraband drugs in that room. What would happen is that the police would use the dog to determine whether there's contraband in the room. The dog would alert if there were drugs in the room, and then the police would go get a warrant after that canine sniff was conducted. The claim in Correa was that the police needed a warrant based on probable cause, just like any other search of a private area, before they could actually conduct the canine sniff. And we agreed that for purposes of the state constitution, there is a warrant requirement. And as a result, we concluded that the search of the room based on the illegal canine sniff was unconstitutional.
Judge, I'm just curious, considering that it was open to the public, is that a case that could have gone either way?
In my judgment, and I wrote the opinion, it was a close case. We decided it unanimously, but when I say it was open to the public, Ernie, what I mean is that
The hallway was.
the hallway was generally, you could walk into the lobby, as I recall, you could walk into the lobby of the motel, and then you could walk down the hallway if you wanted to visit someone. There wasn't who was a guest there. There wasn't a locked door
Right.
between the lobby and the and the corridor that led to the rooms.
There was a prior Supreme Court case that you
Yes.
made a comparison to and found there wasn't a substantial distinction, right?
That case is State versus Kono, which I also happen to write. So
Told you he wrote a lot of cases, right?
So this issue was something I was particularly interested in. We concluded that a dog sniff of a condominium door, where there are other condominiums, it's like an apartment complex where there are other condominiums right next to one another, that was a search that required a warrant based on probable cause. And we concluded that the dog sniff of the motel room was not sufficiently different to warrant a different conclusion.
Okay. Excuse me. Another question we just have for the panelists comes from Stan Marcus, class of 63. Justice Roberts said during his confirmation hearings that a justice's role is to call balls and strikes, but central to many issues that come before the court are fundamental to the relationship between federal and state governments and the way judges think about things. Do judges do more than call balls and strikes? And if not, what do they do? Perhaps define the distance to the home run fence?
I'm happy to take a quick crack at that. It's a very, very good question. I'm very familiar with Justice Roberts's testimony. I happened to just read it again recently, and it's very appealing and it sounds quite persuasive. And judges try to be neutral and objective, but it's very difficult to say that it's no different than calling balls and strikes, that the same two judges in essence should come to more or less the same conclusion, or two judges should come to more or less the same conclusion about the outcome of the case. That's just not the way judging works. What we've talked about today, the living constitution approach or the originalist approach, create sort of different perspectives pursuant to which one views the constitutional language, and different people come to different conclusions based on those different perspectives. So while I have a lot of respect for Chief Justice Roberts, and he's a very, very capable justice and very smart, I don't really agree that what it boils down to is a judge like that on a court like that is really no different than an umpire in a ball game. Judge Baio,
I agree. I think it's obviously there's a little bit of a difference on the trial court level, because the trial court, we didn't talk about this because it's not really within the topic, but the Reader's Digest version is the trial court is bound by the decisions that are made by our Connecticut Supreme Court case. We're not bound by other Superior Court decisions. They can be persuasive but not binding. So, but even there are factual circumstances and that you have to make factual findings to determine what law applies. But I suppose you can kind of make an analogy to calling balls and strikes, but I just don't think it's quite that fundamental.
Yeah.
And then we do have a question, interesting, from Franklin Brosgol. Does the preamble have the same status as basis for law as the articles and amendments?
That's a good question too. The preamble, say in the state constitution, I don't think we've ever really been in a position to look to see if there's a preamble that actually has particular meaning. It's usually very broadly written, and it may afford a litigant an opportunity to sort of make general arguments based on a preamble. But as a general matter, I think the actual text of the Constitution and the history of the Constitution play a more significant role than the preamble. That isn't to say, though, that a good lawyer would not want to rely on the preamble if that preamble seemed to support his or her cause.
Okay, wonderful. We have a few minutes left, and I just was going to turn it over to the panelists. Is any concluding comments they wanted to make?
Well, Matt, before you do that, I happened to notice, for whatever reason, I can see the questions, and I thought there was an interesting one from Natalia Cortez about the process of being selected, or what the process of becoming a justice is. And is one selected by Congress, members, the governor? And I think it's kind of interesting. Never thinking that I was smart enough to be a judge, I never went through that process. But both Justice Palmer, went through the process a number of times to get to the point where he was on the Connecticut Supreme Court. And Judge Baio also has gone through a process, but as a Superior Court judge, continues to be subject to the process. And I think it would be very interesting, especially in light of some of the discussions about judges being elected, that we respond to that question.
Judge Baio, would you like to take it? Or?
I will point out one thing before I turn it over to you, and that is, I think, a significant distinction, which Ernie alluded to in his comments of going through the process a number of times. Unlike the federal court bench, where they are lifetime appointments, Connecticut, and I think Justice Palmer, you mentioned the term earlier, but we have 8-year terms, which means every 8 years we have to go through the process again. And obviously, if you're being considered for a different court, such as moving up as Justice Palmer did, you have to go through it again. But we have 8-year appointments, so we're constantly going through that throughout our judicial career, which is not a bad thing. But and as far as the process goes, it's pretty much the same for both of us. So I'll turn that one over and let Justice Palmer bring this one home in the baseball analogy.
Okay. The way it works is that the governor is responsible for nominating judges to all 3 levels of the courts in Connecticut. That's the Superior Court, the Appellate Court, and the Supreme Court. And the legislature, both the State House of Representatives and the State Senate, is required to vote to confirm. It's just a straight majority vote on candidates whom the governor would nominate. So the governor is actually the appointing authority, but the legislature is the confirming authority. There's another step though, and that's a state agency called the Judicial Selection Commission, which is a group of citizens appointed by different, actually appointed by the governor, and who one has to appear before the Judicial Selection Commission before one can be nominated by the governor, and has to be approved by the Judicial Selection Commission as someone who is qualified by virtue of experience, education, temperament, judgment, to serve as a judge. If the Judicial Selection Commission does not approve the person, then he or she cannot be nominated by the governor. And one has to, if one's applying to be a Superior Court judge, then that's taken into consideration. Same at each level, there's that same review, and one needs to be approved for each of the 3 levels, depending upon which court you're seeking nomination to.
And then there's actually an additional step before you get to the House and the Senate, and that is going before the Judiciary Committee.
Yes.
So there's a huge, you're before the body of the Judiciary Committee with a, a lot, I say huge because it feels that way when you walk in, but there's a large group, the whole Judiciary Committee is there, and it's a public meeting, and it's publicized, and people can watch it if they choose to, and you could be asked any questions. You undergo a background check, and they have, every case that you've, if you wrote a decision in other contexts before, either as a judge, if you're being reappointed, or beforehand, if you have decisions that you were involved in as a lawyer, having argued before various courts. And so you could be asked a whole host of questions, and that's before then they vote to determine whether you're going to go before the House and the Senate. So it's a long process.
Matt, if I can just ask one question that's of interest to me, and I think might be of interest to the listeners. We've all seen the congressional hearings on Justice Kavanaugh, Justice Amy Coney Bryant, and Ketanji Brown Jackson, and they were very contentious, and they were very close votes. Justice Palmer and Judge Baio, is that replicated in our legislative body?
I'm being silent. I'll let you go first.
Okay. Generally speaking, it is not replicated. It's not replicated. It's hard. It's never replicated. I have to say that in my case, and I never saw anything like this before in my case or anybody else, but my last reappointment was somewhat contentious because of the decisions that I decided, I believe, involving the death penalty and gay marriage. And I was questioned about my judicial philosophy at some length. And the vote was a lot closer that time, the last time that I was up for appointment at the end of my career on the court than it ever was before. But it's nothing like the sort of politicized nature of the confirmation process. That experience, my experience, was nothing like the politicized atmosphere that you're talking about.
Yeah, that's right. I think even you're asked questions, and some of them could be perhaps emotionally charged questions, but it's not like the reality TV that we've sadly been exposed to.
Yeah.
Well,
thank goodness.
Well, yeah, amen. Well, I'd like to thank our panelists for really doing a wonderful job of educating us on judicial philosophies on the U.S. Supreme Court and the significant, areas of difference and also, potentially same ground when it comes to our state courts and also not just Connecticut, but across the United States. So thank you very much. I think this was very educational, and I'm going to turn it over to Carmen to close out our talk.
Thank you again to all the panelists this evening, Justice, and to Judge Baio and to Attorney Mattei. Also, Matt, thank you for moderating. And thank you to the audience for attending our program this evening. We look forward to seeing you again. Thank you and good night.